Dr. Nisha Kapoor joined Warwick in December 2018 as assistant professor in sociology, having previously worked in the sociology department at the University of York. Prior to that, she held appointments at Duke University in the US, where she was the 2012 to 2013 Samuel Dubois Cook postdoctoral fellow at the Center for the Study of Race, Ethnicity and Gender in the Social Sciences, and at Manchester Metropolitan University. She completed her PhD in sociology at the University of Manchester in 2010.
Thank you. Assalamu alaikum. I thank you very much for inviting me today. It's a pleasure to be here and an honor. So the focus of my talk to you today is, as Miqdad said, the basis of research that I've been doing, or I have been doing, over a 6-7 year period, and much of it culminated in the book that I published last year called Deport, Deprive, Extradite. And the focus of the book is on, centers around the cases of about 11 Muslim men who were extradited from Britain to the US. I guess before I start, I should ask how familiar people are here with the counterterrorism apparatus of the British. I mean, have you had many talks around Prevent? And so, I mean, I don't want to assume anything, but so what I was intending to do or wanted to do with the book was to move away from trying to differentiate between innocent and guilty, and move away from trying to differentiate between, a way of thinking about the war on terror in sort of in a commonsensical way, in the way in which it gets talked to us all the times in the media, which is a frame that suggests that there's a small handful of extremists, and then the majority of Muslim communities who get racialized and criminalized as part of this apparatus. What I wanted to do instead was to say that actually there was something really important about these extreme cases, extreme not because of the actions of the individuals who were criminalized, but extreme because of the nature of the policing, the nature of the ways in which they were being sanctioned by the state. So that I was looking at individuals who were extradited from Britain to the US, who were deported to countries known for engaging in practices of torture, who were being deprived of their citizenship, who were having their passports cancelled, who were having their children taken away from them. So extreme in the sort of sense of what was being done to them. And what I wanted to do was to look at these stories, tell the stories of individuals where there was being very little written or spoken about, because that's important, but also think about what these stories tell us about the nature of the security state. So what these cases were actually doing for the intensification of authoritarian measures. Because for me, Islamophobia and the kind of racism that has been mobilized and become really intense over the last 20 years or so, its purpose is really about intensifying authoritarian state regimes, like totalitarian. It plays a big role in helping to enhance what the state can, the state powers, basically, enhance the kind of security elements of the state. And so the book is really about trying to tell stories of Muslims which don't get play, or which don't get press, which don't get talked of more on a kind of general playing field. But to also kind of think critically about what these stories or what these cases actually tell us about what's happening, what the state is doing. So Do you all know about Baba Ahmed and Dala Hassan? So obviously in 2001, the first, huh? Yeah.
All the same nationality?
No. So in 2001, the first person arrested in relation to the 9/11 attacks was a guy called Lotfi Rassi. He's an Algerian national living in London. That he receives mass press attention, lots of media attention, because obviously this is the first person arrested. They're living in the UK. The media flag it as this incident which tells us that the war on terror isn't just going to be something abroad, but actually we have domestic extremists amongst us, that there's very much a need for not only intensifying our military interventions overseas, but a need to kind of do more at home. 5 days after he's arrested, he's released without charge. His family members are also arrested at the same time, and they're released. But Rassi is rearrested on an indictment from the US, and the US are requesting his extradition because, on terrorist-related charges. At that time, the law is such that if the US wanted to indict somebody for extradition, they had to provide prima facie evidence. They had to give some basis as to why they were requesting the individual. And so they actually, at that time, only had information relating to some knee surgery that he had had. He had basically trained at the same flight school as the 9/11 hijackers, and he had failed to declare some knee surgery that he'd had on an aviation training form. And this is the basis of what they're indicting him for. And they said to the judge at the time, oh, this is just holding charges while we try and find more evidence to bring a bigger charge against him. And the reason why they wanted to bring him over, it turned out, was because he'd trained at the same flight school and they wanted to question him. So he was detained and he was imprisoned for a few months, and then the judge in the UK is waiting for more evidence to come. Evidence doesn't come, and eventually the judge throws it out and says, he's being indicted on false premises. You can't just extradite somebody because you want to question them. And eventually, actually, he wins like £2 million or a significant amount of compensation from the British government years later. This is 2001. 2002 by the time this is solved. In 2015, another guy called Minh Pham, who's a Vietnamese revert to Islam, had traveled to Yemen and he reverted to Islam at like 21 years old. He was very much a kind of peaceful, devout Muslim. Up until a certain age, he wanted to do more. He became more politicized. He wanted to do more to help. He'd spent some time in I think, Bangladesh, staying in mosques, helping kind of poor communities. He wanted to do more. He kind of got in with some folks who it turns out he didn't kind of agree with politically. But he ended up in Yemen swearing allegiance to Al-Qaeda and worked on he was an artist. He worked on one of the magazines, doing some art illustration. He returns to Heathrow Airport and is arrested on return. And he was in possession of a large amount of money and a few other items. He was arrested. He was released without charge, but he was placed under surveillance. And a few months later, he was stripped of his citizenship and indicted for extradition from the US. And both of these things happen very quickly. And so what you see over this period is 2001, where it's possible but very difficult to extradite somebody by 2015, with Min Phamb's case, you can extradite somebody and deprive them of their citizenship very quickly. In the space of this period of time, we've had like a massive escalation of state power and a massive escalation of state power to do things very quickly in the name of the war, on the back of the war on terror. And so what I try to do by telling the stories of these cases is, as I was saying, to think about kind of what kinds of state powers are legitimated on the back of the criminalization of these people. And I guess what I'm suggesting is, for the most part, the basis of the arrests and the basis of the criminalization is is activity that in other contexts would be defended as freedom of speech or as freedom of expression. So in Baba Ahmed's case, the basis of his criminalization is running a website in the 1990s, which post-2001 is branded to be a terrorist website, but the website is simply, for the most part, just repeating secondhand media about the Bosnian War. Dala Asan worked as a mail clerk for the website and is arrested and is charged and serves a very lengthy period in prison for typing up a document, an unsolicited document, and putting it on the website. We have Mahdi Hashi, who allows an acquaintance to stay in his apartment in London. And this acquaintance goes on to travel to Pakistan and has links with some Al-Qaeda type group. And because he allowed this person to stay in his apartment, because he allowed this person to use his phone, because he allowed this person to bring luggage into the apartment, which had ponchos and socks in the bag. Ponchos and socks were later labeled as Al-Qaeda military training gear. He's arrested and charged on material support. So the basis upon which these individuals are being criminalized are, for the most part, these kinds of activities. There's a couple of cases where individuals, I'm not saying that there isn't activities occasionally that are more serious, but for the most part, these early cases, the cases that get high-profile attention are Muslims who are being criminalized for very little. But the scope of counterterrorism legislation means that you can be criminalized on the basis of very little. So material support charges mean that you can be found guilty just by association of, so just the fact that you allow somebody else to stay in your apartment, or that you haven't shown willingness to change the behavior of somebody else who's deemed to be suspicious. So it means that, anyone that you're connected to or linked to becomes sort of a threat if they themselves are criminalized. So what I wanted to do with the book is think about how is it possible that what happens to these individuals is possible, and so there's a couple of things that I try and think about. One, it's important to think about Islamophobia, racism, the trope of the terrorist, and the role that this notion of the terrorist, this idea, this caricature, the ideological work that it does for legitimating all kinds of activities. So because you are criminalized as a terrorist or as a terrorist suspect, legally you are, the state can enhance the kinds of ways in which it can criminalize you. So if you're charged with terrorism-related offenses, even if they're things like material support, as I just mentioned, or those kinds of activities, you automatically are facing higher lengths of pre-trial detention or you can be detained for longer periods without charge. You can be questioned more rigorously, often without legal protection. You're going to face higher charges. There's lots of additional ways in which the police or in which the state can kind of target you just on the basis of being charged with terrorism-related offenses, whatever that is. Um, and if we think if we go back and sort of chart the way in which the discourse, the narrative of terrorism is used historically and in the contemporary, there's a particular genealogy which shows how it's linked historically to, colonialism. So after the French Revolution, the way in which the term terrorist gets used is in the context of resistance against empire. So we have, it being used in the Irish context. We have it being used in 1920s India. We have it being used in Malaya. We have it being used in Kenya. The way in which anti-colonial insurgencies groups get characterized is as terrorists, as a way to delegitimize those movements. Not to suggest that everything that gets called terrorism is progressive. It's not necessarily, but the kind of way in which the language and the words get used does have a racialized history, and it's very important to understand and think critically about that when we think about its use in the present day. The other thing is, with extradition, one of the very clever things about what happens with these cases is that, unlike extraordinary rendition, does everybody know what that is, rendition? So one of the principal techniques that's used post 9/11 to capture and interrogate suspects in the war on terror is this process of rendition, which is kidnapping and transferring individuals illegally from one place to usually a clandestine prison site, either somewhere in the global south, directly run by the US or through one of the US's partners or allies. When that comes to light, when journalists expose that this is happening, there's uproar in the European Council. It turns out that some of these black sites were in Eastern Europe, in Poland, for example. The European Council condemns this as a violation of human rights. And Poland, for example, gets told off. But unlike extraordinary rendition, extradition, because it proceeds through a legal process, a recognized legal process, it doesn't receive the same kind of critique from the human rights quarters. But when we look at the process of what happens to Muslims who are extradited from Britain to the US, there's a lot of similarities between these processes in terms of the very lengthy times that people are incarcerated pre-trial. So Baba Ahmed is, imprisoned in this country for 8 years pre-extradition, and then 2 or 3 years in solitary confinement in the US before he enters into a plea bargain. Because after you've spent 2 or 3 years in solitary confinement in the US, you're more than likely to enter into a plea bargain. And you'll notice with US terrorism cases, often the sentence, the punishment is much worse pre-trial or pre-conviction than post-conviction, and that's because the punishment comes as a way to try and subdue or to subjugate individuals, to persuade individuals to enter into a plea bargain rather than go to trial, because it ups the number of guilty pleas that the US can say it's attained in terrorism, generally across the criminal court, but certainly in terrorism cases. So you have a system where punishment comes first, and then charge comes second, and the crime comes last of all. And so what happens in these sort of extradition cases is there's a big parallel between what's happening illegally or extra-legally, but whereas the European Council is condemning rendition, the European Court of Human Rights says that 80 to 100 years in a supermax prison in the US, much of which would be spent in solitary confinement, is not tantamount to torture because these are terrorist-related offences. And so on the back of these being terrorism cases or terrorist offences, regardless of what they actually are in real terms, there's a massive allowance or escalation of what the state can do or what can be done on the back of this. And so there's a few things that I kind of chart as being the consequences or being expanded through these kind of extreme terrorism cases. The first thing is we have a growth of secret justice. So do people know about SICM, the Special Immigration Appeals Commission? So in 1997, there's a Sikh guy who is fleeing, who had been back to Punjab and had been tortured. It was when the Amritsar massacres had happened, the kind of uprisings in Punjab at the time, and he's tortured by Indian security state, and he comes back to the UK and he's arrested here. The British authorities are working in conjunction with the Indian security forces, and he's faces deportation. And at that time, if you were facing deportation on the back of terrorism charges, you had no possibility of, you had no right to appeal. There was no legal process in place. And he appeals to the European Court of Human Rights, and the European Court of Human Rights say that, that there's a problem. And so on the back of this decision, on the back of this case, this court called the Special Immigration Appeals Commission is set up, which in deportation cases where individuals are being deported for national security reasons, this court hears those cases. This court is made up of 3 judges and no jury. And this court can hear evidence in secret, which means that the person who's appealing against deportation doesn't necessarily see all the evidence against them, nor does their lawyer, but they're appointed a special advocate, and that special advocate, once they see all the evidence against the person they're representing, isn't allowed to communicate with the person they're representing. So it's a secret court. It's a colonial administrative system, but it comes into play in 97. It's used a couple of times up until 2001, and then post 2001 with war on terror, it begins to be used more frequently. Post 2007, it begins to be used even more. So on the back of, so what some of these cases help illuminate is the way in which we have this expanse of a secret justice system that's used selectively in terrorism cases in this context, in deportation cases, but over this period has actually expanded and has, because this technique has been tested out in an immigration court, which is seen as being, outside the regular criminal justice system. It has subsequently been used in employment tribunals, in all kinds of other administrative courts, in family court, and actually in 2015 for the first time in criminal court, where they tried to hear the first terrorism case in part of it in secret, and they managed to do that. So we have the kind of growth of this process, the expansion of this process becomes normalized. It becomes, so in criminal court, a judge thought it was okay for part of the hearing to be heard in secret, for part of that hearing to not be available to the people who are being, to the defendants of that case. The other thing is that we have an expanse of the use of the possibility to deprive people of their citizenship. So in 2002, the Sun, the Daily Mail, start a media campaign against the presence of Islamist preachers in Britain, and they start this kind of rhetoric saying that, they fixate on Abu Hamza al-Masri, and they say that, he's the kind of domestic Osama bin Laden. There needs to be more done to get rid of him. He should be deported. And there's a massive campaign that starts calling for the deportation of Abu Hamza. But because Abu Hamza is a British citizen, he can't be deported. And so the Sun and the Daily Mail request their readers to kind of write in and complain. And David Blunkett, who's the Home Secretary at the time, receives a raft of letters from the public demanding for Abu Hamza to be deprived of his citizenship. David Blunkett, the Home Secretary, understands that something needs to be done. And in 2002, on the back of, as part of an immigration and asylum bill that's being passed, or an act, they include an amendment to that piece of legislation which says that the British government can now deprive people of their citizenship, enhances the powers for being able to do that in a way that hadn't been possible before. And Abu Hamza becomes the first, and this amendment is informally called the Hamza Amendment because it's in his name that it's passed. And he becomes the first person to be deprived of his citizenship. He actually appeals and he wins his appeal, so he gets it back. However, this piece of legislation is on the books. It's not used very often. In 2006, another piece of legislation is passed, which expands the state powers again to deprive citizenship. And this time, the piece of legislation says that the British government can expand, and it's on the back of another terrorism case. And the British government says, well, if we believe it's conducive to the public good, we can deprive some of their citizenship. So in 2002, it's the legal jargon is to say that it has to be in the interest of British foreign policy or British imperial interests. In 2006, the threshold is simply if it's conducive to the public good to deprive somebody of their citizenship, we can. In 2014, on the back of another terrorism case, Theresa May argues that there's a need to enhance powers again, and it becomes possible to deprive somebody of their citizenship even if they don't have another citizenship, but if the Home Secretary believes they can acquire citizenship elsewhere. So in 2014, in the name, on the back of this case, whereby an individual had been who had already been deported or sent back to Iraq, Halal al-Jada is his name, who was appealing to come back to the UK and couldn't come back to the UK, so there's no chance of him being a threat. On the back of his case, nevertheless, Theresa May argues that there's a need for more legislation. And in 2014, this piece of legislation is passed. It's this legislation which is used to deprive Shamima Begum of her citizenship. It's this piece of legislation which has been used to deprive Min Pham of his citizenship when he is extradited in 2015. It's this piece of legislation which has, I think, been used in a number of cases more recently. So when we look at the deprivation of citizenship, it's still small relatively compared to, the number of people, for example, who might be deported when we look at kind of immigration statistics, or in relation to the number of the size of the Muslim community, or the size of marginal communities in the UK as a whole. But nevertheless, we see this kind of growth in the use of this measure. The last 2 years, in 2017, about 104 people were deprived of their citizenship just in 1 year. I'm not aware of what the figures were for last year. I don't know if they've been officially released yet, but I'm guessing they're probably around the same. So the powers are there for this to be done. And usually, so what the Home Secretary will argue is that if, for example, you're Bangladeshi and you're British, you were born in Britain, you don't have any other citizenship, but one of your parents has Bangladeshi citizenship, and the Bangladeshi state says that if your parents have citizenship, you can apply. The Home Secretary will use this as argument to say that you could apply to Bangladesh for your citizenship. That's the kind of logic that's being used, and it has been used in a couple of cases, in a few cases. And there are other cases too where there's just no possibility of an individual getting citizenship elsewhere, like Min Pham, where nevertheless they've been stripped of their citizenship. So that's another measure that's being used. And the third thing that I should mention is the European Court of Human Rights. So one of the things, so pre-Brexit, one of the key things that comes associated with high-profile terrorism cases is this argument from the right, in particular, about the way in which the European Court of Human Rights is being misused, about human rights being used by individuals who don't deserve human rights. And this is one of the reasons why we need to move away from the European Court, right, from Europe more broadly, but specifically to move away from the European Convention. And so when Abu Hamza is extradited with Baba Ahmed and Talal Hassan and others, a story erupts again in the media where they say, we need to look at, in this case, thankfully, the European Court of Human Rights has come good, but, we need to revisit the European Convention. We need to kind of think more critically about why it's been possible for the European Court to deliberate so long on these cases. Why is the European Court working in the favor of individuals identified as terrorist suspects? In reality, the European Court, as I mentioned before, has been very harsh in terrorism cases. It hasn't been as lenient as the press would make you believe. But when I kind of looked at the judgments of the European Court in relation to the UK to try and understand why the right, in particular in Britain, was so keen to move away from the European Court of Human Rights, one of the things that becomes apparent is, although it hasn't, it's said that you can extradite individuals to the US because they're facing terrorism charges and they can face hefty punishment. It has condemned Britain in relation to its actions in Iraq, in relation to its military interventions that it sees as being kind of overstepping the mark. And this is this idea that this argument that's used by other academics, other intellectuals, who have looked at, who do work around kind of Palestine and Israel, who note the way in which humanitarian frameworks have been used in imperialist or military interventions to argue that if we make these kind of these forms of violence or these violent techniques more humane, then they're seen as kind of liberally more legitimate, or not so, not torturous. So if we can torture or interrogate somebody in a particular way which doesn't meet a certain kind of threshold or which complies with certain kind of humanitarian frameworks, it's not seen as torture in the same way that something that was kind of all out brutal. There are ways in which human rights are coming in to sort of pacify or to appear to make less violent certain kinds of techniques of torture. And in a way, the European Court seems to be working in a similar fashion. So whereas it allows for certain activities to be, it legitimates certain activities to happen as long as they happen within the law, like extradition, they'll condemn other activities that seem to be kind of a step too far. And of course, this makes life difficult for the British government when it wants to do what it wants to do in Iraq or Afghanistan or Pakistan or in its its military interventions overseas. So I kind of draw on. I'll finish in a minute and open up for questions, but as the project has progressed, we looked at, or I interviewed individuals who had their passports cancelled, women who had been, I mentioned that there's been an increasing number of cases that are now going through family court. So since about 2015, the number of women being arrested under counterterrorism charges has also increased quite significantly. It's still a small number relatively, but it's been on the rise. And it ties in with the use of secret evidence or with the use of family courts as part of the counterterrorism apparatus. So one of the ways in which counterterrorism policing works is that up until recently, it has evaded going through criminal court. It uses the immigration system, right? It deports people, or it deprives them of their citizenship. It avoids kind of open criminal court where evidence has to be presented. It's preemptive policing for the large part. And the way in which family courts are being used are that women, men and women, but disproportionately women who are being questioned, but who can't be charged with a criminal offence because there's not enough evidence to be used by the police. The police are handing that evidence over to social services, and social services are using that evidence to argue that the children are at risk of radicalisation. And so you have cases where evidence that's been collected by the police is being used by social services and family courts to punish in another way. And there's a film. I have a website as part of this project. It's called Deport, Deprive, Extradite. It's dde.org.uk. There are 2 films on that website. One of them is called Eyes of Aliyah, and it tells the story of a woman who is stopped as part of a Schedule 7 stop, but who ultimately has her children taken off her. She has fought back and has more access to those to her kids now, but it kind of shows the way in which family court has become another avenue through which counterterrorism policing is being used. And so I guess I'll just end. I hope. Well, I know it's been a little depressing, but there is, and certainly has been, really important and great kind of mobilization and resistance amongst, against many of these actions amongst Muslim communities, and really great organizations that do much to support families who are impacted by these activities. And I think at the moment there's a kind of quite an important movement for moving against things like prevent and these kind of harsher measures. So there is optimism in the resistance.
Thank you very much. If it's okay, can we have Q&A after prayers?
Oh,
yeah.
sorry.
Is it okay? No, is it okay?
Yeah.
So what we'll do is we'll have Salah right now, and then straight afterwards we'll have some time for Q&A. Thank you very much. Salawat.